for. Thank you. Thank you very much for being here, and welcome to everyone. My name is Matthew Baird. I'm the Director of the Asian Research Institute for Environmental Law, and I'm very excited to be here in Geneva with colleagues to talk about some of the issues on ASEAN environmental rights and how the development of the Environmental Rights Declaration in ASEAN has thrown up some very interesting and quite challenging perspectives and opportunities, but more importantly, how in the context of the recent decision on the advisory opinion from the International Court of Justice on the obligations and rights of states with respect to climate change, I think has going to sort of provide a real fast track, real excitement of opportunities going forward. So the first speaker today will talk about some of the issues on the draft ASEAN Declaration on the right to a clean, safe and healthy and sustainable environment, which we've been working on for a number of years. So some of this work predates the submissions to the International Court of Justice, and it certainly predates the opinion. It also predates some of the other extraordinary judicial decisions that have happened through the International Tribunal of the Law of the Sea, the ITLOS decision, and there was also a decision by the European Court of Human Rights and the decision by the Inter-American Court on Human Rights. So we've seen an extraordinary amount of jurisprudence being developed over the last 12 months, which I think for me, as a sort of a jaded environmental lawyer who started practice 35 years ago, has really energized me, I think, in terms of some of the opportunities that we have to look at the context of environmental rights, both procedural and substantive, and perhaps make it a way forward for actual significant action on both climate change and environmental issues. And I think that's where I see this really interesting opportunity is emerging, to use some of this jurisprudence from the International Court of Justice in conjunction with the other pronouncement made by regional tribunals, working in both regional and international levels to sort of focus on what we mean by environmental rights, both the procedural and the substantive, and more importantly, how we can actually see genuine change affecting individuals and groups, communities, Indigenous people who are currently facing, significant trauma, significant hardship as a consequence of genuine climate change. I also think, one of the exciting things, and our speaker, Nicole Ponce, will also talk about this from the perspective from World Youth for Climate Justice, is also how the International Court of Justice made it quite clear that there was no room for further debate about climate change. The science was so settled, which I thought was settled in 1992 when the world's leaders came together with the Framework Convention on Climate Change, but certainly made it clear that the science is so overwhelming. And I thought the other really extraordinary thing about the unanimous decision of the International Court of Justice was the focus on liability. And I think this is going to be a huge opportunity to change behaviour of the polluting countries, of the fossil fuel countries, knowing that they are clearly liable at law for their actions and their failures. How that eventuates, how that applies in domestic litigation or further international litigation is still a big question that we're going to have to answer, and it won't be answered in the next 5 years. It might not be answered in the next 10 years, but I think that's also where we now know that it will be answered, and I think that is very, very exciting. Within our context tonight, we're going to look a little bit about what is happening in ASEAN, and so I'm going to introduce our first speaker, who's going to talk about some of the procedures, some of the background to the development of this first ASEAN Declaration on the right to a clean, healthy, safe and sustainable environment. So Rocky Guzman is the Deputy Director of the Asian Research Institute for Environmental Law, ARIEL. He is an environmental lawyer and policy specialist with extensive background in oceans issues. He has been he was the campaigner for Oceana in the Philippines and has been involved in a number of different environmental issues for Southeast Asia with the Asian Development Bank, UN Environment Programme, and Sustainable Ocean Alliance. Rocky obtained his law and political science degree from the University of the Philippines and his master's of environmental policy from Duke University. Rocky, over to you.
Great. Thank you, Matthew, for that kind introduction, and good afternoon, everyone. I'm very happy to be here in Geneva for the second part of our Geneva series. I'd like to thank our hosts here in Geneva, the Geneva Environment Network, and of course, CL, for welcoming her here in the occasion of the Human Rights Council session as well. So for this afternoon, I'm going to discuss, some developments and some exciting things that are happening on the other side of the world in the Southeast Asian region, where we are currently developing the first declaration on the right to a safe, clean, healthy, and sustainable environment. And I'm going to, discuss some of the things that have happened in my capacity as one of the former working group members of this ASEAN Environmental Rights Working Group, which was tasked to develop this first draft. And I have also here Matthew and Max, who are also part of this working group. It has been quite a long, arduous, but quite meaningful journey for the past 5 years, and we're almost at the end of the first part, where we're going to have the first declaration set to be signed by the ASEAN leaders by next month in October during the ASEAN Summit. But before I go to those details, let me just contextualize first on what's happening at the ASEAN level, on the plight of the environmental human rights defenders in particular. So if you look at some data, some hard and fast facts from the past 10 years, the past decade or so, you'll see that this is really a hotspot of attacks against EHRDs. From data from Global Witness says that there are around 18% of killings happen in Southeast Asia. A lot of them happened in the Philippines, where I'm from, but there are also a lot of significant numbers in other countries such as Indonesia, Thailand, Cambodia. Now, these are just numbers on killings. There are also cases, a lot of cases on enforced disappearances, for instance, harassment, vilification, physical injuries, and all those. Many of these are perpetrated by state agents, and a lot are also, perpetrated against marginalized communities, in particular indigenous peoples. So that's the context of what's happening in ASEAN right now, and that's the context. That's why we need to develop this framework on environmental rights to have these safeguards for protection for EHRDs. Now, in the past 5 years, it started around 2022. The initiative was started by the ASEAN Intergovernmental Commission on Human Rights, or what we call ICHAR. And the ICHAR sought to bring together existing ASEAN commitments and international obligations in a comprehensive and a cohesive manner. Now, this is quite different in most ASEAN instruments, as the development was to be determined through a collaborative discussion by different stakeholders through the constitution of an ASEAN Environmental Rights Working Group. So this was to achieve a holistic approach and enhance the coherence of this regional framework. And while we were doing this, we drew, at the conception, we drew from international experience from other MEAs, from other access rights agreements, including regional instruments for the substantive elements as well as procedural elements. So I'm going to discuss some of these elements that we discussed throughout the whole process of development. And some of these might be in the first draft of the Environmental Rights Framework, first declaration of the Environmental Rights Framework. So first, I'm going to discuss some of the substantive elements that we discussed in the development. So a lot of these, of the contents really come from the global developments in the international law. You have the UNGA resolution and the UNHRC resolution that prescribes the right to a clean, healthy, and sustainable environment. But even before then, that was 2022, right? In 2012, ASEAN already had a version in the ASEAN Human Rights Declaration, and that's the right to a safe, clean, and sustainable environment. So taken all together, we have the right to a clean, safe, healthy, and sustainable environment. And we also discussed substantive rights. That includes the right to clean air, safe climate, healthy ecosystems, safe and sufficient water, sustainable food, and a non-toxic environment. And we also discuss, some issues that are pertinent to the region, some issues such as oceans and the marine environment. So these are some of the references that we put in the discussions on the development of the substantive elements of the framework. The second part of the bucket of elements that we looked at as well are the procedural elements. And of course, these are procedural rights that are necessary to achieve the right to a healthy, clean, sustainable environment. The legal foundation is, of course, Principle 10 of the Rio Declaration, which prescribes the fundamental procedural rights, or what we call the access rights, access to information, public participation in environmental matters, as well as access to effective remedy or access to justice. But we also, took cognizance of subsequent regional developments that prescribe, the establishment of a safe and enabling environment for EHRDs, or environmental defenders, to exercise their rights. So as you can see here, these are some of the frameworks, global and regional frameworks that we looked at, and we drew inspiration from for the procedural elements of the framework. So we have the Aarhus Convention, of course. Very happy to have the Aarhus Convention here to discuss some of these elements as well, but also more recently the Escazú Agreement, which is based in Latin America and the Caribbean, which prescribes for the safe and enabling environment for EHRDs to exercise their rights. So we also look at some elements, including on transboundary EIA from the Escazú Convention and strategic environmental assessment from the key protocol. And all in all, we put that in the development of the procedural elements in the framework. So I've discussed two things, the procedural elements and the substantive elements. And now I want to show where we are now at this point in the development of this declaration. So we started formally around 4 years ago in 2022, where the working group for the ASEAN environmental rights was constituted, and we had around 5 working group meetings then. Last year was our last working group meeting, and it was resolved in that meeting that we would endorse or refer the draft declaration to the ASEAN bodies and the ICHR itself for their deliberation and process. It was also because there were a lot of issues that we couldn't get consensus on. There were a lot of brackets, and it was deemed, more productive for the ASEAN delegates to discuss on those issues. So that was last year, and the working group was disbanded around July 2024. And now the ICHR has been going around the ASEAN sectoral bodies and going through consultations with the governments as well. And we're expected to have this declaration presented and signed by the ASEAN leaders by next month in Kuala Lumpur for the next ASEAN summit. So hopefully we'll have something by next year, by next month, not next year, by next month. But the thing is, we don't know what might be the contents of that declaration. It's been 1 year since we've seen the draft, so we don't know what has happened in that interim period. But we hope that it will be a robust and comprehensive declaration that would provide, the starting point for a framework at the national level for policy reform. So the next step, logically for ASEAN, the ASEAN processes is that there would be an implementation plan or a plan of action, and that might happen once this declaration has been signed by the ASEAN leaders. So we'll see how that goes as well. Now, I'd like to focus on a few key challenges in this whole process of developing the ASEAN Declaration. And I'd like to focus on 3 things. The first one is on the content itself. So as I've said, when we disbanded last year in July, there was a lot of disagreements on the content. And the one that we referred to the ASEAN body, to ICHR, was a text that was full of brackets and alternates, because there were 2 positions, 2 main positions among the working group members, whether it should be a statement of broad principles or whether it should be more comprehensive and robust framework discussion. The issues that garnered a lot of challenges in getting consensus included reference to indigenous peoples, EHRDs, substantive elements, and environmental impact assessment. So those things we didn't get consensus, and we hope to see them also in the next version in the draft. Another issue was on stakeholder engagement. And this I really want to focus because there was a lack of transparency in the whole process, which is a pity because this is an access to information and a public participation document. But the whole process was replete with issues on transparency. There wasn't any effort really to have the draft disclosed at every stage of the process. There was only that was publicly available, and that was the draft that we had at the start of the process. So people didn't know, civil society was in the dark on what the current version was as we went through the process. There was also no effort to let people know of the status of the drafts and submissions. There was a consultation period, which was about 1 month, but that evidently was not enough to hold meaningful consultations, and it was left to the working group members to hold these consultations with our stakeholders. So there was and there's no support institutionally for coordination in a period, like a longer period for all these consultations. So that has been a main challenge. And the last one is on representation. So as we expect to have this declaration signed, and there's no formal body where civil society is included in the process now, since the working group was disbanded. We don't know the future of how the ASEAN or ITAR would engage with CSOs. So that's something that we have yet to see. Hopefully, when we go to the implementation plan or development of the action plan, then CSOs would have the seat on the table again to have like meaningful inputs to the process. But we don't know if that might happen. So these are some of the key challenges. There are many more in this journey, but these are some of the things that really stood out in this whole process. But we are still hopeful. The implications of the first ASEAN Declaration on the right to a safe, clean, healthy, and sustainable environment is very important. It's quite a landmark development. This regional approach would then provide impetus for developing a stronger enabling environment for environmental rights, for the protection of EHRDs. That would translate to national policy reform. So this would necessitate reforms in policy, regulation, and judicial procedure to uphold environmental rights. Now, in all this process, we really hope that, we were happy that we were included in the process, but we really need to make sure that throughout this process and the next phases, that the ASEAN would continue to engage with stakeholders and ensure that public participation is upheld. So I'll end there. Thank you very much for your time, and I'm really hopeful we have something next month, some good news to share with all of you. But again, thank you very much, and happy to take your questions later on.
Thanks, Rocky. And our next speaker, Max, do you want to set up? One of the things I think, as sort of Rocky mentioned, that in talking about ASEAN, it's not an organization that's necessarily well known in Europe. It's 680 million people. So there's a few people there. 10 countries at the moment, hopefully 11, with Timor-Leste maybe joining in October this year. It is a supranational body, but it's not quite like the EU. It doesn't have a rulemaking, but it does have a number of treaty obligations. In environmental treaties, they have 2 or 3. The ASEAN Human Rights Declaration, which was developed in 2012, is still very important. But we still have those challenges about whether it's binding law or non-binding, which was one of the interesting issues about what that may mean in the context of an advisory opinion as well. So we will now move on to our next speaker, Max Hahn. Max is the co-founder and executive director of Youths United for Environment, and Max is which is an award-winning grassroots non-profit mobilizing youths for environmental action through storytelling, campaigns, and advocacies. And since 2019, Youth has been reached over 50,000 people, probably more by now, engaged with global institutions, including the UN, EU, and Malaysia's central bank, and now advises Malaysia's Ministry of Environment. Now, Max was a member of the working group representing the ASEAN Youth Forum and the drafting of the Environmental Rights Declaration under the ASEAN Intergovernmental Commission on Human Rights. Max has been personally recognised for his work by the UN Messenger of Peace, Dr. Jane Goodall, and was named by Prestige magazine as Malaysia's 40 most successful, innovative and influential people. He has received the Princess Diana Award, Tatler's Gen T Leader of Tomorrow, and the North American Association for Environmental Educators 30 Under 30. In addition to some of those obvious accolades, he has also the distinction of being a Rhodes Scholar for Malaysia at Oxford University, a National Geographic Young Explorer, and the first Southeast Asian to be named a future Nobel laureate scholar. Max.
Thank you, Matthew, for that very warm introduction. It's an honor to be here in Geneva and to chat about a very important issue that's happening in Southeast Asia concurrently. And I'm a Malaysian climate activist and also an ex-member of the working group. But all those titles aside, I'm going to push that away and come to you today as a storyteller. I think in settings like Geneva or UN and a lot of these technocratic spaces, there's a lot of push to reach the mind. But when we talk about human rights, I believe that stories are what reaches the heart. And so today I'll try to do both. I hope to reach your mind by giving you an overview of the ups and downs of this policy process, but I also hope to reach your heart by bringing forth a vessel of a collective consciousness of everyone advocating for change in Southeast Asia and the communities that have given me permission to share their stories with you all. So I hope you'll be kind to me as a storyteller as I share with you very candidly the good, the bad, the ugly, and the hopeful of this declaration that we're drafting in ASEAN. So let's start with the good. So Rocky has covered a lot of it, but essentially what is really progressive about this declaration is that it covers the substantive elements, so the what of environmental rights, about clean air, having a safe, clean, healthy environment, and also the procedural parts, the how to get there in terms of access to information. And it draws on very forward-looking agreements in ARAS, ESCAZU, and it's hopefully going to inspire more push in other regions for human rights as well. And this is really important when we situate it in the context of Southeast Asia. It's almost 10% of the world's population, a huge part of the economy in the global economy, but most importantly, it's a region that's very rich in natural resources. So almost half of ASEAN's land area is covered by forests, and with the rise in demand for renewable energy, we have the demand for minerals with tin, nickel, and gold coming into focus, and a lot of that is situated in Southeast Asia. But what also surfaces with that tension is that a lot of communities are also affected by this demand for natural resources. And so it's really imperative that we have a declaration that focuses on such things like environmental rights. But all that aside, how does policy actually come and how does policy actually work on the ground? Unfortunately, this is the bad part of my presentation. And Rocky has presented hard, fast facts, but I think it's always important to put faces and stories behind these issues. And so I bring forth some stories from grassroots communities to really illustrate the plight of environmental defenders in the region. So this is my friend, Alat Miraso. She's from the Philippines. She is a community activist and she working on climate change, land rights, indigenous rights. And 22 years ago, Alat lost her father. So her father was a peasant activist, and what happened was that he was red tagged and also subjected to enforced disappearances. So all this jargon aside, an activist can sometimes be tagged as a terrorist and be subjected to kidnapping. Until today, Alat's father has not surfaced, and she understands her father through the work of activism that she's doing today. And she's giving me permission to share this story because it's important to remember that environmental defenders are more than their titles of activists, of land rights activists, of fighting for indigenous rights and all. They're also family members, their fathers, husbands, daughters, wives, and human beings fundamentally. And it is important to remember that the environmental defense is not a crime. A lot of these protests are actually done peacefully. And in Malaysia as well, this has also taken on many other forms, and it's not just in the Philippines. So this is another one of my colleagues, Celine Lim. She is an indigenous rights activist from the Kayan tribe in Sarawak, that's in Borneo, Malaysia. And in 2021, she was slapped with a $1 million lawsuit from a logging company when their small indigenous grassroots organization reported, the infringement of rights on their land for the sake of logging. And this was a very big case. And luckily, the good news is that they actually reviewed this case, but it took a long legal battle and a lot of international solidarity and attention to even bring forth this case as well. So Celine is actually one of our activists that have been involved in the declaration as well. And this is something called strategic lawsuit against public participation, or SLAP, where it's a tactic to intimidate and prevent communities from sounding the alarm or voicing their rights. And imagine this, if someone breaks into your home and threatens to kick you out, what are you going to do? Are you going to sit down and take it, or will you protest peacefully? And this is really a simple analogy that really describes the crux of the matter that is not just in Malaysia, but everywhere else in Southeast Asia. And if you look at the trends, Philippines ranks highly as well, but so do other places, which makes this region one of the most dangerous regions in the world for environmental defense. And a lot of the key perpetrators have been state, major businesses, and the trends have been evolving. It's not just lawsuits, it's also tagging activists as terrorists, tax evasion as well, and finding many different crimes to file environmental activists under. And amidst all this landscape, indigenous people, farmers, peasant activists are most affected. And also lacking in a lot of policies to also protect a lot of these environmental human rights defenders to defend their rights. So putting all this in focus, this framework is really, really important. 80% of environmental defenders killings are happening in Asia. 80% of the killings in Asia are in ASEAN, which means this region is really, really important when it comes to protecting the environment. And so I want to flip the narrative. I want to invite everyone who works on environmental issues. We're taught that we need to protect trees, we need to curb emissions, and all these technocratic measures. But I want you to think about this differently. By protecting those who protect the environment, you are in effect protecting the environment, because these environmental defenders have been the best environmental stewards for generations and generations to come. And it's important to remember that humans and the environment are inextricably linked. So how does the policy process in ASEAN come to protecting these environmental defenders as we're trying to do? Unfortunately, this is the ugly part of my presentation. There were many challenges in the policy-making process. So Rocky is detailed. Transparency issues, funding issues for consultations as well. I'm going to give a little bit more detail. A lot of the consultations actually fell on the burden of civil society to run these consultations. We submitted most of them, and we only had 1 month to put that together. So put that into perspective. We have so many diversity, so many languages in Southeast Asia, right? Not just the traditional languages, but also indigenous languages. The effort it took to translate them and work on so little funding. Actually, our movement actually used our per diem for the policy meetings to run these consultations for hundreds of people. And that was a really, really tricky process. And I also really want to credit the power of young people in making this work. And despite all that, issues like indigenous rights, environmental human rights defenders came up in the consultations, impact assessments. A lot of them were still dismissed in policy meetings as well. So what happened with the original start of 19 pages became reduced down to 4 pages. And until now, we don't know if this substantive and procedural part of the good part of my presentation is even in the final draft as well. And a lot of things also got removed. And it's really important to remember that indigenous rights are a key aspect when it comes to protecting environmental defenders in Southeast Asia. So I'm inserting this statement from the Asia Indigenous Peoples Pact. A lot of the policymakers pushed back because there was the perception that this term, indigenous peoples, was colonial, despite it being recognized in international language, the UN DRIP, and even in ASEAN documents, the term indigenous has been there. There was a lot of pushback on this. And the quote from the Coalition of Indigenous People is that the importance of self-identification. It's important to remember that this is an umbrella term, and indigenous peoples are not a monolith. They're diverse, and the ability to have themselves recognized in policy and allowing this space for self-identification is really, really, really crucial for their rights. And when we push for this, there was a lot of pushback, and these are some real-life accounts of some of the delegates at the working group. So one of the indigenous representatives was met with a lot of verbal abuse, intimidation and harassment, Many of the working group members as well had experienced this, and it was not a very civil environment to be advocating for many sensitive issues as well. And this was a first attempt for ASEAN to engage civil society, but it's also really important on what we accept in terms of the bar of engagement with stakeholders. And it got so bad that some of the special rapporteurs came together and actually submitted a letter to the working group and to remind everyone of what we are fighting for when it comes to a lot of these environmental rights issues. And most ironically, in a framework that is supposed to protect environmental defenders, more abductions happen. I remember that day when my UN colleagues' phones were just pinging away because some youth activists in Cambodia suddenly got jailed for years, and they're as young as teenagers. We need to prevent further attacks and recognize that this is a life or death matter and not just a policy exercise. So despite all this, having detailed really macabre and stressful issues, we had to get really creative in our strategies. So there was no Indigenous representation in the working group, so we had to bring them in. We gave them our badges and we brought in an Indigenous elder. And actually, this was a very useful exercise because in Southeast Asia, we have respect for the elderly and those who are older than us with more experience. And so that made discussions a bit more civil when it came to engaging with policymakers, with the Indigenous elders as well. And because of them, I really believe that the term Indigenous peoples were bracketed. We fought for it to the very end. Whether it's still in the final draft, we don't know, but as we left it, it was still there. And we also mobilized a lot of coalitions, and we came up with our own declaration, and we submitted this to them to be tabled. Hopefully, they come across it, but this was something that was drafted by civil society to really reflect our demands. And most importantly, when it comes to transparency issues, it is so difficult to really bring people on board to this and let them know about this. So we had to really engage international media. This was not an easy process. It was a lot of press release writing, and it's not easy for media outlets to report on such depressing issues like human rights abuse, especially for state-controlled media. But we were lucky that we managed to get the Diplomat, Manga Bay to cover all of this. And we were also strategically engaging local medias as well. And these spaces like Geneva and other policy spaces also, it's important for us to build solidarity, even in international spaces, to bring these issues up to attention. So some lessons learned, as with every story, there are some lessons. One, I think this engagement, particularly with Indigenous issues in ASEAN, is that decolonization is not a metaphor. The trauma of colonization has made its way and has a legacy in policy. And as we know, on one hand, ASEAN is very wary of issues like this, but for Indigenous people, it's a life or death matter of getting their rights recognized. And I love this quote from Fanon that is a historical process that we cannot really ignore and we're still trying to grapple with. And I think this declaration is a really practical experience of doing that. But most importantly, we need more leaders who feel pain, especially the pain of those living in the consequences of decisions they make. Even in spaces like Geneva, where it seems utopian, it's really important to remember the realities of those on the ground. And on our side, we also have to hold ourselves accountable. We cannot also wait for our leaders to act. And the young people in Southeast Asia is putting up that fight because this declaration is going to be signed on by our governments. And as we know, Southeast Asia's political cycles change a lot. This will live through generations and generations and generations to come. So with that, I thank you for your solidarity and remember to defend the defenders.
Thank you, Max. So we're going to move on to Nicole. We're going to go from ASEAN to the world. But I also should make sort of a little bit of an acknowledgement that the work of the ASEAN Youth Forum and Max and his colleagues during the working group was simply exceptional and just changed the narrative as well. And I think from that, in some ways led to certain responses from ICJA, which was to exclude some of the voices that they needed to hear. But I think there was such a fundamental change in the way people, because this was one of the first times that ASEAN had really focused on community participation. And I think in some ways they were shocked by just how much was able to be achieved in such a short period of time. But it wasn't just also people within ASEAN who were supporters, and we're going to hear a bit from one of the people that provided us with extraordinary amount of strength and support, and that was Fiona from the Aarhus Convention, who provided us with often a shining light in the darkness. So our next speaker, as we now sort of move on to thinking about the advisory opinion from the International Court of Justice, Nicole Ponce from the Global Advocacy Lead, the World's Youth for Climate Justice. And she is an environmental and human rights lawyer from the Philippines with a strong interest in the intersection of law, science and policy. And she holds degrees in both political science and law, has a background in research and is a member of the Philippine Bar. She currently serves as the Global Advocacy Lead and formerly as the Asian Front Convener of World's Youth for Climate Justice, which she also co-founded. In addition, she works at the Centre National de la Recherche Scientifique in Paris and as a research officer. And on 23rd of July, 2025, it seems so long ago, but it was still only a couple of months ago. The Global Youth Movement and the ICJ Advisory Opinion Alliance, led by the World Youth for Climate Justice and the Pacific Island Students Fighting Climate Change, secured the unanimous decision from the International Court of Justice in response to their request for an advisory opinion on climate change and human rights. And following this historic ruling, Nicole is determined to use the advisory opinion of the ICJ, of ITLOS, and the Inter-American Court on Human Rights to advance ambitious climate action at both the regional and domestic levels through negotiations, litigation, and advocacy. So, Nicole, for you.
Thank you so much, Matthew. It's great to be here. And thanks for the warm welcome. My friends already said thank you, but it's always a pleasure to be here. Well, I'm not sure it works, but okay, perfect. I have my own timer as well, Matthew. I'm conscious of the time. I'm conscious of the time. So, as I mentioned yesterday in yesterday's session, since 2019, since we've worked on asking for an advisory opinion from the International Court of Justice, this really comes as a high point for me to be speaking about the implications of the advisory opinion for my region of Southeast Asia. Because in 2019, with friends from the Pacific, there was just general consensus that we need to be doing this because the decisions that are made up to this day in response to climate change will rob us of our future. And we felt that it was important to make a statement that we refuse to be on the sidelines and we refuse to be reduced to victims. Because while communities drown and are displaced, those who are most responsible and those most profiting continue to act like basic human rights are up for debate or that it's optional. But the general theme of this discussion is that climate justice is not optional, it is a matter of legal obligation, and the court just reaffirmed that in its advisory opinion. Just a quick refresher on the question posited to the ICJ essentially was that what are the obligations and duties of states in response to the climate crisis, and equally important are what are the legal consequences. And the ICJ thankfully gave us so much to work on, so I'm going to do my best to condense all that and in terms of the overarching principles, because I know everyone here has done I know probably you guys have read it from start to finish, so I'm not going to dwell so much on that. But I guess it's also really important to emphasize how the ICJ referred to the need to use best available science in response to these obligations as presented by the IPCC, and also to establish factual context and to inform obligations. And then, of course, the court also confirmed the 1.5 degrees Celsius is the agreed primary temperature goal under the Paris Agreement, and that responsibilities are understood as evolving, and that there is a need to factor in historical contributions to cumulative greenhouse gas emissions, the levels of development and national circumstances, the application of the principle of common but differentiated responsibility and respective capabilities. And also the court was very strong on nationally determined contributions that state must prepare, communicate, maintain, register, and account for their NDCs, and that failure to do so is a breach of legal obligations, and that NDCs must collectively be capable of achieving the temperature goal of limiting global warming to 1.5 degrees. So this means that states have limited discretion over NDC consent, contrary to what many states often say, that this is a voluntary pledge. It is not, it's now a legal obligation, and that each NDC must reflect its highest possible ambition, make an adequate contribution to the collective 1.5 degrees goal, and become even more demanding every 5 years and be informed by the global stock date, which, if we see, shows that the world is off track. And I'd like to emphasize this one, highest possible ambition, because for the longest time since we started this, we've been told again and again that what we've been doing is too ambitious. But I think that's exactly the point. Ambition should be the benchmark, because that's precisely what we need, ambitious climate action. And we are just happy and relieved that the court reaffirmed that. And also spoke of the relevant conduct to assess state compliance with their legal obligations, and that compliance under both treaty and customary law covers fossil fuel production, consumption, subsidies, and licensing. And in some circumstances, these may amount to internationally wrongful acts. So all states must provide for and conduct environmental impact assessments. And of course, also it spoke about customary law, which arises from consistent state practice carried out with a sense of legal obligations. And these legally binding obligations apply to all states, even those outside climate treaties or that withdraw from them. So one of the very important things that the court reaffirmed was that in terms of the applicable law, because many, especially from our colleagues who are knee-deep in negotiations, many of these difficult states shield themselves in terms of accountability because they work within the language of the UNFCCC and the language perhaps of these climate treaties, but we forget that there are other sources of obligations that go beyond these. And in fact, I'll be saying later this, for example, the duties under customary international law, which again, the court has reaffirmed. It re-emphasized the duties, including preventing significant harm to the climate system, due diligence, precaution, regulating both public and private sectors, including corporations, and of course, the duty of cooperation for climate protection. I think these duties already exist even before the Paris Agreement under customary international law. And what we're trying to do is hopefully reinforce that message that there are existing legal obligations that go beyond these climate treaties. And we're just happy that the court reaffirmed that as well in its ruling. And one of those state obligations is under the international human rights law. I really like this phrase when the court again reaffirmed that the environment is the foundation for human life, upon which the health and well-being of both present and future generations depend. The court thus considers that the protection of the environment is a precondition for the enjoyment of human rights. And I emphasize this a lot because I think we all felt that the court understood what the people were trying to say, because they were saying that what the question posed upon them were not just legal questions, but they're existential problems of planetary proportions. And I think by that, we were able to get the message across. And one thing I like to also really emphasize in these discussions is that sometimes people think that the youth were separate from the court, that we were outside mobilizing and we had no involvement whatsoever in these proceedings. That's entirely false, because we launched the Youth Climate Justice Handbook that was even used by states to craft their submissions before the ICJ, often referencing, annexing this Youth Climate Justice Handbook. And we even brought voices from frontline communities to The Hague through our witness stands videos. So I think this is quite novel in the sense that the ICJ has always been a bit of an enigma, and not a lot of lawyers, and even lawyers, not a lot of lawyers are able to engage in this process. But now, not only were we able to engage lawyers, but even frontline communities. If we couldn't bring the court to the communities, we bring the communities to the ICJ. And that was also very inspiring to see. And we heard that we've heard, we see that the court was able to understand and see the plight of these communities who are experiencing the brunt of the effects of the consequences of climate change that they did have nothing to do with. So yeah. And again, as what Matthew and Matthew, Rocky, and Max here or already mentioning earlier, the right to a clean and healthy, sustainable environment was also reaffirmed, again, a precondition for the enjoyment of many human rights. So at the outset, we really felt the need to establish that connection between climate change and human rights, because climate change is a risk multiplier. And the fact that it was again reaffirmed by the court in its advisory opinion is really a great day for climate justice. So what does this advisory opinion mean for Southeast Asia? As what my friends here have already emphasized, they're doing amazing work on the ground. The ICJ, as I mentioned yesterday, is not a silver bullet. It's not meant to solve all of our problems. Otherwise, we won't be here. But hopefully, it will build on already the brilliant, impressive work that so many of communities, NGOs, civil society are doing on the ground, amplify that and use it as leverage, as authoritative reference to have more ambitious climate action, be it in policy, in litigation, advocacy, campaign work on the ground. Hopefully that's what we're trying to see and work with everyone. Will it mean governments in the region will be under pressure to ramp up climate policies? We definitely hope so, but also, the idea is that to be completely honest, because this is a historic, it's a landmark ruling. It's also very much unprecedented. What we're trying to do right now is to do a lot of these unpackings. Also, why we're here, try to analyze the implications of the opinion and how it can build on all these negotiations that's already happening. And hopefully, that's what we can do and brainstorm and discuss later on if we have much more time. So I'll end with that. And just to say, because up to the lead up to COP, the court was also very strong on that and emphasized that COP decision may have legal consequences. So I think that's a good thing to remember while we prepare for COP. So I'll end with that. Thank you very much. And I'll give it back to Matthew.
So thank you, Nicole. And, I think that one of the things that clearly World Youth for Climate Justice were able to do is bring those stories to the court. And I have heard and listened to quite a lot of talks and webinars on post advisory opinion, and all of them talk about how those stories actually meant that the judges were confronted not with just an opinion, but with something that was really going to impact on people. And I think you can see that in the judgment. But I also, as I say to Nicole, I also think that one of the most extraordinary things about this entire process was the fact that this group of Pacific Island students fighting climate change, sitting in a university in Vanuatu, asked their lecturer what they could do to make a difference, and this is the result. And one of the things that I find that story, and it's the power of storytelling, is just people said it couldn't be done, so they did it. And that is without doubt one of the most powerful stories that I know, certainly in terms of litigation, especially at the world's top court. So thank you, Nicole. I mean, both for the presentation and also for the inspirational work over the last number of years. So I mentioned now, after the presentations, we have an opportunity to have a few sort of interventions or observations. And so I'm very pleased to ask Fiona Marshall from the Aarhus Convention to make some observations. And after that, Francesca and Yves, who are here, can also make some observations, because part of it is for us going back to Southeast Asia, leaving the beautiful chocolate and fondue hub that is Geneva, and going back and working out, well, what's our next step? How are we going to implement these? How are we going to make sure that the whatever declaration comes out of the ASEAN Summit in October, we can actually use to make a difference? I mentioned I mentioned the light in the darkness. I don't want to think that this is Galadriel's light that contains the shard or the hair but it was often discussions that we had in Geneva, I think 3.5 years ago, when Ariel first started this journey looking at an environmental rights declaration. We spoke to Fiona and we got the A to Z of the Aarhus Convention. We got some copies annotated most effectively, but that was one of the foundational documents that we use. The Escazú agreement had also given impetus, but we went back really to the the trustee Aarhus Convention on those procedural rights, and also one of the things that emerged during our discussions was the establishment of the special rapporteur provisions, which we don't have in ASEAN, although now the current chairman of ICJA, Edmund Bond, the Malaysian representative, has raised the idea of ASEAN establishing that as a potential mechanism for responding to the crises with environmental defenders. But that would not have happened without the extraordinary friendship and great professional support from Fiona. So it is a great pleasure that I turn it over to you for some observations on the process and where we are at the moment and what can we do next.
Thank you, Matthew. So actually, in terms of story, this is the room here tonight is you have a group of 3 visionaries here, because you have the young people who created and brought the case for the advisory opinion. You have the people who made the ASEAN Declaration happen, and you have the previous generation who as youth created the argument that these.
That is a good story.
And so actually, when I first came to Geneva as a law fellow with the Centre for International Environmental Law in their Human Rights and Environment program, the TL told me about how there was this human rights activist in Geneva who was not a lawyer, but he was wanting to help people who are bringing cases to this new compliance committee that had been set up just about to start hearing cases, and could do with a litigation lawyer to help people bring cases before the compliance committee. And that human rights activist was Eve. And I hadn't heard of this convention that it was about, but it was called this Aarhus Convention. So I went and met Eve, who was looking for a litigation lawyer to help them with cases before the compliance committee. And so they were the first cases that the compliance committee ever had, the first 4 cases. So we were trying to help people, like people from Turkmenistan who were not even able to bring their own case, present the first cases before the compliance committee. So this is in terms of visionaries. I mean, you are each creating incredible change for the world. Yeah. So now for us, we get to live every day with the reality of that incredible change that Eve, when he was youth in Europe, actually made happen. So now that we are at this stage of that the declaration is going to actually come into being in a month, which is an incredible achievement. It's interesting to look and think about the next stages and how to make that live and breathe. And I wanted to share 4 experiences from the Aarhus Convention, which obviously they will be done in a different way for the ASEAN region, but the ideas could be useful to take forward. And so the 4 ideas that I want to share is some form of reporting mechanism of the declaration, some form of advisory assistance mechanism, compliance mechanism, even though the declaration is not binding as such, some form of rapid response mechanism to protect the very, very real risk for environmental human rights defenders, and some form of rules of engagement for how you can have civil society actually in the room, at the table, when the discussions are happening, and not just waiting in the dark to possibly see what the declaration that is supposed to be about their own rights might actually end up being. So those are the 4 things that I wanted to share. So I think it could be useful to first start with the some form of reporting mechanism. So the Aarhus Convention has a reporting mechanism that works on a cycle. And one of the important things about that is that each time there is a report that the state has to prepare, it must be prepared in a participatory and transparent way. So civil society must be involved in the preparation of that draft. So there must be opportunities to discuss the draft. There must be meetings together between civil society and the government when they're preparing that draft. And then the report must be public. First one. Second one, some form of advisory, assistance, compliance type mechanism. So given that the declaration is not binding, it's better that it's going to be framed as an advisory and assistance mechanism. The Compliance Committee of the Aarhus Convention has gone the reverse way, because it was established as a compliance mechanism, but actually increasingly we are acting as an advisory and assistance mechanism. So we actually took the founding decision of the meeting of the parties that established the compliance mechanism and found some wording in it that we could use to make it an advisory and assistance mechanism, which is increasingly used. So for example, in this last couple of years, we have, for example, been preparing an advice to Ukraine for how it can still maintain its Aarhus rights whilst it is under a military attack by the Russian Federation. So this is the type of mechanism that in the beginning it was a compliance mechanism, but it actually moved because states realized that it's actually really useful for them to be able to reach out and also get advice and assistance. So we've had 4 or 5 advices that we've been working on in the last year or so. So yeah, and states are proactively reaching out to get that. Then the third mechanism I wanted to speak about is the rapid response mechanism to protect environmental offenders. It's very exciting that you told me that the chair is actually already open to this idea, because obviously, I mean, it's a life and death mechanism. It works, it needs to be able to respond in a completely different way to the advisory assistance mechanism. The advisory assistance mechanism will likely be quite procedural and considered. It will need to hear from different views to make sure that it's going to provide a advice that's fit for purpose. The rapid response mechanism needs to be able to intervene, take quick action, protect people's lives. So under the Aarhus Convention, the rapid response mechanism only actually started 3 years ago. So it was a response from Belarusian civil society that were facing persecution, that they stood up and made an incredibly powerful intervention in 2019. That was when the thought, the seed got planted, and so this mechanism was established. And then the meeting of the parties adopted this mechanism in 2021. The first Special Rapporteur, Michel Force, got elected in 2022. He now has 97 cases. Yeah, so I mean, and his cases are including cases, as you may be aware, include the Philippines. Yes, because the rights under the Aarhus Convention are not limited by citizenship. So, yeah, Manila Bay has, yeah, it's one of our cases. Yeah. Anyway, so that rapid response mechanism to protect environmental defenders. And the fourth one, rules of engagement, to actually make sure that how these mechanisms get established happens in a transparent and participatory way. So there is rules of procedure for the Aarhus Convention. They were adopted at the very first meeting of the parties. And some of the things that are really useful in there is that, for example, speaking rights is actually, the speaking rights are not that all the governments get to speak first. And then when they're all finished, then observers get 5 minutes or 1 minute. Actually, there is the idea that in theory, speakers are supposed to speak in the order that the flags get raised. So it actually means that civil society gets to speak when it's relevant to speak on this topic, rather than once the discussion's gone way beyond that topic and they get a little moment to speak and maybe there's not time. So actually putting in place these rules of engagement at an early stage before any form of mechanisms get actually drafted would be very, very useful and good. Yes. So those are the four things that I wanted to share, and it's very humbling to be here with all of you, to actually see you changing the world in real time.
And we're excited that we're with Eves because
You can be seen. Anyway, Francesca was first. So,
Yes.
I'm Francesca. Yeah.
Okay, so there needs to be over there. The next results across different processes. And we already started our conversation yesterday, but it's interesting to reflect on how different fora and mechanisms can really influence each other. And it's really great that you reached out to Fiona and to the Aarhus Convention to infuse some principles and approaches in the ASEAN process. I don't really have comments, but rather open questions that we might want to consider, since we're now here with Geneva-based institutions, also those of you are in the ground in ASEAN. And it's how can we, on one hand, make Geneva more aware of the developments in ASEAN, because we said we work a lot in silos. And here in Geneva, I mean, here also at the Council, we tend to focus on what's happening within the Council, but not that open to external processes. And I think it's very interesting that at least now some more attention is being paid to the ICJ advisory opinion, but really, how do we make sure that also regional developments enter this space? And vice versa, how can we ensure that processes like the Council or special procedures can have a concrete influence on the processes? I thought it was very interesting to see the letter that was sent by special procedures to the working group. I don't know to what extent it had any effect. And I think it would be also interesting to reflect on how initiatives like these are received in the region, to understand what's most effective or not. Here we have the UPR, the Universal Periodic Review. It's a peer-to-peer review process led by states, but maybe in some of the guiding questions that states ask the state under review, we could think of some helpful language. We have treaty bodies that review various states parties to the convention they oversee, and of course ASEAN members are also part of this convention, so we could think of what's the role of these treaty bodies to make meaningful recommendations. So I think there are different ways to go about it, but definitely your expertise in understanding how broader and international processes are received at the regional level, also conscious of the ASEAN way of work, would be very helpful. Thank you.
Thanks. And I also, just should take the time to acknowledge Seelan, to say, this is the first time, we've been invited, and we really appreciate that. I mean, I came to a Human Rights Council meeting a number of years ago. A friend of mine, Justine Nolan from Australian Human Rights Institute, and I sat through a number of sessions, very much focused. There was a lot on Africa, a lot on Latin America, and very, very little on Southeast Asia or ASEAN, with its 689 million people. So I mean, again, with the Geneva Environment Network and with SEAL, we're here now, and we really, really appreciate being here, because it can feel a long way away. And I think that's also one of the exciting things, is how we can do some more collaborations to get some of these ideas and work going forward. Edmund Bond has talked about the idea of a rapid response mechanism or a complaints mechanism under ICJA, that we're not sure how that will play out with other members of ICJA. The other interesting thing is also that in the 4 years that we've been working on the declaration, 4, 5, yeah, there's also a lot more interest in a legally binding treaty. So when we did our consultation, 98% of civil society that we consulted wanted a legally binding obligation, and ICJA and the UN bodies just said no. And yet that's what civil society want, and that was completely ignored. But one of the things the lessons I think we took out of that process was that there is now a lot more discussion about some of these elements, which may also include some countries considering whether or not to join the Aarhus Convention, even in ASEAN, because there's a lot more discussion about it. And for example, just recently, both Indonesia and Thailand have announced that they want to join the OECD, which of course requires them to accept the grievance mechanism. Not sure if they've read that part of the data, but it also shows that, if they're prepared to do it in economic terms, or for economic instruments, maybe there's obligations. And one of the strongest fights we had was whether to include due diligence and risk assessment as part of the elements within the declaration. And I had a number of arguments with ICJA delegates, representatives saying this was a European construct. And I said, no, this is the document that I've downloaded from the ASEAN website. It's called the ASEAN Taxonomy on Sustainable Finance, that includes due diligence, risk assessment, and a phase out of fossil fuels. That's all in the ASEAN document, signed by ASEAN member states and developed by the ASEAN financial and central bank teams. And they were saying, no, this is a European thing. I'm saying, it's not, it's yours. And so there was that disconnect between sort of talking about what was ASEAN, what was international and elsewhere. But I think there's a lot more movement now because of that discussion, which was also one of the comments you made to us, is keep talking about it, talking about it.
Just to say that I was signed up with SOFIA guidelines, so it was 2 years before I was adopted there with SOFIA guidelines.
So also, I must say I didn't know that experience was in the room, because perhaps as an archaeologist, I enjoy, the old history, but we were really, inspired by the absolute commitment that Fiona showed to Aarhus and to the developments of it, and the fact that it wasn't a static document. I think that was also the interesting thing, that it was something that was people trying to constantly make relevant. So, please.
Yes, well, thank you very much, and thank you, Fiona, also for your very nice words and reminding me and reminding us about old times, but still remain very, very relevant today, actually. And I want also to thank you for having come to Geneva, and it's great. This is a bit of an initial process, I hope, in this discussion. And I want to continue in the line of what Francesca has said. I think we definitely need to see how we can, how a dynamic can be developed, where we reinforce each other's work by what we're doing here in Geneva, so that you reinforce what you're doing, and what you're doing also can reinforce the work we are doing. And I think, like Francesca said, there's a lot of work to be done to think and work out of the silos in which we all are. And to be very concrete, one element which is probably going to come already in 2 weeks' time is that there will be a seminar which is organized by the Office of the High Commissioner, following a resolution of the Human Rights Council on. They have a regular seminar. I think it's every 3 years, if I'm correct, between the UN and the regional mechanisms. And the next moment will be in a few weeks, and it will be looking precisely at the question of the right to a healthy and sustainable environment. So there will be, so very, very quickly, the program. A number of our friends who are on the program. Ciel is on the program with Sébastien Duic, and so we will hear from different regions what are the developments. We had also another opportunity that was last year with the Geneva Roadmap 4011. So 4011 is the number of the resolution of the Human Rights Council, that recognized the importance of environmental defenders, and it was adopted without a vote, which is quite remarkable and worth being underlined today. And so there's a follow-up mechanism we're trying to do to see how this is implemented. And we had a discussion last year in this framework with the Geneva University, actually, with Peter Larsen from the Geneva University on the different regional mechanisms. And we did spend quite some time on precisely this development of this ASEAN Declaration. Leah from the Philippines, that you know very well, she did an excellent presentation of that. So just to say that there's a number of channels to be reinforced. They need to be more developed. But I'd like to go on, perhaps continue the reflection on what you've said, Fiona, because I think it was really a remarkable way to think about next steps, and not just to stop at what probably will be a disappointing document. Let's be very clear. NGOs are very disappointed by the process, and they're right to be disappointed because it started pretty well and then was downgraded from step to step. And of course, it's worrying when we know the importance of the Asian region in today's world dynamic. So we need definitely to think about it. And probably we're going to have to think of it in a new, fresh way. And I think all the elements that you underlined, Fiona, are interesting to see how can we try to develop these type of dynamic, knowing that probably the intergovernmental bodies in Asia, which anyway, none of them cover the whole of Asia. You have South Asia, Southeast Asia, then you have the forum with the Pacific. They're all part of the same UN region. When you know also there's another region, which is Central Europe, that seems rather unbalanced, as the least to say. So, but anyway, we have to deal with that. But I think it's interesting to see how can we develop these type of dynamic on participation, on reporting. That's because that's something which is quite interesting. For example, and I'm here just throwing some ideas on the table, but how could we link this with the UPR mechanism, the Universal Periodic Review? Perhaps would there be some kind of regional mechanism that could be developed by the civil society to, take benefits of the UPR mechanism and make some complements on it, so that perhaps you would have some kind of a regional approach of the UPR mechanism, because all of the countries have to report. But then civil society could all have an Asian discussion on these elements, for example. So here is a way to try to develop this, with the different forums. And I mean, it would be really great if you had such a discussion within the Pacific Forum, within the ASEAN, within the Southern Asian organization. I mean, this is just food for thought, but it could help, to develop that, to go beyond the frustration we're going to have by a 2-week document saying, okay, great, you're saying this, we're going to use it, this will be the next step. And that could be one way to put it. And participatory reporting could be really something very interesting to strengthen, because it can be very easily moved afterwards. Once you have a real formal mechanism, it's going to be very easy to move it in. So that could be an interesting way to continue to work on it. The question of assistance and advisory mechanism, I think, was a very, very good one. Probably the difference we have in the process, it's because of the very strong credibility of the compliance mechanism, because they did a great job. I mean, the members did a remarkable job over the years of giving very, very strong advice, very strong findings, and to the point that even the EU, and we hope that will be the case also at the next MOP, at least once already had to change its own rulings and the way they were functioning. We hope it's going to be the same thing for the second case. So it showed that there is a strong importance. So also then a number of states started to say, okay, before we get into that, let's go and ask an advice before we have an issue. So the dynamic might be a bit different. And again, here, if some kind of advisory mechanisms, expertise, I don't know, network of national institutions and universities, something like that, could start to say, okay, you states are doing mistakes here. This is how we can try to work on it. That also could be one way to push to try to go forward with that. And then again, some of the what is coming out of the Aarhus Convention and the Escazú Agreement of their bodies can be good format to say, oh, this is how we're going to format it. So you structure the whole thing, and then you push to go forward. And of course, finally, well, not finally, but at least with the question of the special rapporteur, the rapid response mechanism, what was interesting in the discussion that happened within ARUS is that the case of Belarus that Fiona mentioned, which is the founding case, is that there was everybody realized that actually there was a bit of luck, if I can say, in the very bad development that were happening in Belarus, in the sense that one of the organizations that was being dismantled by the authorities with no reason had presented a case, and in more than once, actually, 2 communications, I think, in which were successful communications. So the compliance committee considered this type of act can be considered as an act of retaliation, which is of course forbidden under UN standards, and they reacted on that basis. But the compliance committee was very clear, saying if there had not been a communication before, there would be no way for the compliance committee to take up these issues, and they would have been just as serious. And actually, many other environmental organizations are in a very serious situation in Belarus, but the Aarhus Convention has no body, literally, to take up these issues because they didn't come before. And that's what triggered the reaction that developed the idea, okay, we need a rapid response mechanism. What could be a rapid response mechanism? Well, having a special rapporteur, something which is similar to what has been developed in the human rights, in the UN Human Rights Council. And so that's how we have now this procedure, which I think is quite a very interesting innovation. And it's interesting because the Aarhus Convention, and the Compliance Committee is an example of that, is one of the places where those working in the field of international environmental law have looked at what are some interesting developments within international human rights law that can be beneficial for environmental law. And that started with the Compliance Committee, for example. The idea came from the treaty bodies in the human rights system. So here we have a second example, which is similar. So I don't know how we could think of having like a regional mechanism that could be also developed. It would be great if ever your body definitely thinks, okay, we're going to take up these issues. That would be a wonderful development, which is very, very needed. Now, if you don't have it, what could be the alternatives? How could you have a special rapporteur, an ombudsman? Or I don't know, for example, could there be an alliance of the most effective national human rights institutions that could together produce something that could develop a mechanism? Again, here I'm saying, okay, there's going to be disappointment with the declaration. Here is what to build next, on such an issue. And of course, I mean, civil society engagement in that would be extremely important. That's why, for example, if there is a possibility to continue with the dynamic that has been developed through the declaration for the civil society, I think here there are a number of paths that could go forward in order to overcome, as I said, the deception that is foreseeable of what will come next month.
And I think from our perspective, it is this idea of expecting disappointment. It's working out how you can turn what we have and use those experiences going forward, which I think is really important. I also think, from our perspective, we do think that there will be really some great opportunities to work out more how we can access some of the Geneva-based bodies. But also perhaps some advice on how to also get UNESCAP to be a bit more like ECLAC, what you see, I mean, I think, one of our greatest disappointments after we had very strong support from an individual who then left, and the person who replaced her was not of the same mind, and that also ruled the process. So when you have ESCAP actively against public participation and civil engagement, even the stakeholder engagement plan that had been approved by the working group, and they were fighting that. We had a lot of discussions about that, and it was complete contrast to the ECLAC in Latin America and the Caribbean and the work in achieving the Escazú agreement. And so that was also something, dealing with those bodies, given that they are state-based bodies. And that's, I think, something also that came across a little bit tragically, at the end of the process when the UN sort of reverted to a state-based institution rather than supporting civil society, which was quite a surprise for us because we were arguing principles that were from the UN, and they weren't necessarily supported by the UN delegates at the table. And that was quite an eye-opener and a bit shocking in some respects from our perspective. But I think the exciting thing is that is trying to work out how we can move forward, and some of it has to be looking at those institutions or approaches that have worked. And the other has to be trying to work out how we can perhaps leverage with some of the existing sort of institutions here. The Universal Periodic Review, I mean, I think in most Southeast Asian countries, I don't know anyone who has a public participation component for that. You know, I've read the reports, but you know, in Cambodia, I think they've never consulted anyone on their human rights issues. But that might, and it's interesting in Thailand, for example, because of concerns over the EAA process, some academics have developed this public EAA, which sort of is a parallel process to provide that input. And maybe there are opportunities for parallel processes that could also provide some assistance to the council and those mandated processes. I also note the time. Did anyone, Max, Nicole, sort of final words? Fiona?
Just one other thing, financing, funding.
Yeah.
Sorry.
Finance.
Finance. That's the other component to already work out how that's going to be a sustainable line. And because even in the rich Europe, I mean, there's an article yesterday about the European Court on Human Rights that is completely under-resourced and struggling. Certainly, the Compliance Committee and the Sister Rapporteur desperately need further resources. So, I mean, it's something that if you can actually think of that already going in as resilient, sustainable financing.
I have suggested that the Australian government could drop off one of its nuclear-powered submarines, which would save about 160 billion, and we could invest that in human rights and the environment. But I don't think anyone's interested. But yeah, I think. Final comments, thoughts, Nicole? Yeah.
Thank you for the information. It's just really good advice. Yeah, very difficult, I guess, to implement. I think, as I mentioned in my presentation, ASEAN has a wariness to the UN and the North when it comes to human rights, and also from its own people, which is really at the crux of the problem that I presented about, and a wider philosophical question about decolonization. And so I think the way we need to navigate this is to really look at all these alternative mechanisms, and also funding to the people, to beyond just policymakers, but really the people who are living with these consequences and feel this pain the most.
So, Francesca, can I say again, thank you. For us being here has been fantastic yesterday and today. I mean, we wouldn't be here without you and the Geneva Network on the Environment. I mean, again, it's bringing the voices to Geneva, and that I think is something that we hadn't thought about 4 years ago when we first met Fiona. Again, our inspiring light. And Yves, it's been a great pleasure, and now we know who to come to for all the old history.
Don't show Fiona first.
Fiona can tell the news stories, but although you were there, right, running those first cases, it's always lovely to
Very
see.
naively.
It's always lovely to see where those troublemakers, become the troublemakers there become, troublemakers inside the system as well. So, which has been so. But and for us also, I mean, we were truly inspired by, the conversations we had about Aarhus and the idea that, yes, it takes time. These things don't happen overnight, but there were processes that could really sort of open up the access to information and public participation, which we put, very much as the prime focus, challenging as it may be. Again, thank you all very much. Thank you for attending, and hope to see you next year.
Come back soon.
Thank you. Thanks a lot. And thanking tech team. Thank you. Tech
Harvey.
Filipino.